Welcome to the Ask the Expert Show with local celebrity hosts Steve-O and Renee. Sit back each week while Steve-O and Renee educate you with live in-studio experts, such as lawyers, doctors, home improvement, and financial experts in their field. Call in and have your questions answered each week at 888-565-1470. Now, here is Steve-O and Renee with today's expert in their field.
And welcome. I'm going to say good afternoon again. Good afternoon. And welcome to Ask the Experts, the show that brings you the finest experts in South Florida in the areas of
the
health.
top experts.
What did I say?
The finest, but they are the finest, but they're the top experts.
Guess who this voice is? Actually, I had one of our sponsors go, that Renee just kills me.
I killed it with my New York accent.
I guess so. We have an incredible show today. Are you worried about your house losing it? Are you behind on your mortgage payments? Are your mortgage payments too high? Is your mortgage as much or more than the value of your house? Is your family a victim of the economy or the falling real estate market? Has foreclosure already started and they're just waiting for you, hiding around the bushes? Are you trying in vain to get your mortgage company to work with you on any kind of solution? Are you tired of always getting a different person when you call and getting different answers? If this rings a bell, we have the greatest show today because we have the, in our opinion, which we have to say, so the bar doesn't get upset, the finest, the best foreclosure defense attorney, not just in Broward and Palm Beach, but all of South Florida. Let's welcome Bilu.
Welcome to the show, Gil.
Hey, it's great to be back. Thanks so much for having me. And I just want to start off with something today because, I know Steve probably worked on that for an hour.
Did that ring a bell?
To get that down. He probably took it right off my website, but he reads really slowly. I'm not saying nothing about Steve, but he told me it takes him 2 hours to watch 60 Minutes.
I love it. I love it. He came with shtick. I love it.
Well, listen, I got something real for you today, right? So I always try to tie something in. Now, you guys have your food show that you do, right? And what's the big nouveau bird that everybody's eating? Ostrich. Oh, no, nouveau.
Ostrich.
Come on, ostrich.
Nobody eats ostrich.
Oh, my God. I see it on every menu. I don't eat it. But what's the interesting thing about an ostrich? What do you think about when you see an ostrich? Or what does it do? Trouble comes up. What does an ostrich do? Bury their head in the sand. And you know what? I hate to say it. I have people call me all the time that acted like ostriches. I say you're worried about losing your house. Well, if you let it slip through your fingers, you've got no one to blame but yourself. And I'm not looking to lay blame here. It's the season to give thanks. It's a season to be happy. But you got to fight for what's yours, right? And so what happens? Inevitably, I get 2, 3, 4, 5 calls a week. Somebody going, hey, I have a judgment sale. I have a sale coming up for a judgment. You think you can help me? Sure, I can try to help anybody. But, first off, you got to help yourself. And so, inevitably this person comes in or I get them for a phone conference. And, the beauty of technology now, I can go right away, pop online. I can see exactly what's going on in your case, what's happened, where we are. Can't see all the documents, but I can see what's happened. Right?
What they forgot to tell you.
What they definitely forgot to tell me. And one of two things has happened. Either they just ignored it. They got that summons. They put it on the counter. They didn't think about it. They didn't do anything. And the bank can go in and do something called, can get something called a default, right?
And what is the time frame? Because I was going to ask you that question. What's the time frame when you stop paying your mortgage till you start getting notifications from the banks?
Well, it's going to vary from servicer to servicer and even from owner to owner within a servicer. So you can have some owners that are, some of the banks or investors that hold these loans, they'll wait 6, 7, 8, 9, 10 months before they file. I've seen some wait over a year before they file suit. I've seen some 3 months, suit's filed. It just is going to depend. Bank. Right. But once you are a defendant in a foreclosure suit, once the bank says, okay, we've had enough, for whatever reason, we're filing a suit today, what's going to happen next is they're going to get a summons. Summons is an order from the court saying, look, you've been named as a defendant in the lawsuit. From the day you receive this, from the day the process server knocks on your door, disturbs your dinner, hands you a summons and complaint, you've got 20 days to file a response. Well, what happens if you don't file the response within 20 days? If you don't file that response within 20 days, the next step that the bank is going to take is their attorneys are going to run a military check on you, make sure you're in an active service in the military.
Why? How does that affect it?
Well, there's something called the SCRA, the Civil Service Relief Act. SCRA? I'm not sure. SCRA. It's a Civil Service Relief Act. So what does that say? If you're overseas, if you're, and I've dealt with this for clients. I had one client who was deployed to Afghanistan on a Coast Guard ship, right? And his homeowners association decided to file a lawsuit, and I had to go in and fight it, and I was able to fight under those service provisions. But get back to that. That's really, really a very, very small portion of what we do. The bank is going to file for a default. They're going to ask the court, say, look, this guy hasn't responded. He's past his allotted time period. Nothing's been filed. Can we please have a default? The clerk, not even a judge right now, the clerk, this is just, a functionary within the courthouse, looks at the file, says, okay, they filed a motion for default. The defendant hasn't filed an answer. It's been more than 20 days since they were served. Default's entered. Now what happens? Now that default is entered, technically, you're not allowed to answer anymore. It's like a big piece of duct tape's been put over your mouth.
So you have to get an attorney. You have to attain an attorney.
Well, you should, because I have people that make big mistakes doing it themselves, and I'll talk about that in a second too. But,
yeah, like me.
But like you, absolutely, right? So they put the
big mistake.
They put the duct tape's now been put over your mouth. Now, if we're still at the beginning of the case, I can usually get that default lifted. Why? Florida courts, and I just went through a hearing on something like this where it was a timing issue. But basically, Florida courts, has been a longstanding precedent with the Florida Supreme Court dating back to the mid-19th century, that we prefer in this state to have something go to the merits, that you have a chance to defend yourself, you have a chance to open your mouth, you have a chance to talk, right? You have a chance to defend it. They don't want to see somebody win by default. They want to see somebody win because they're right. Now, I can go and I can get that default lifted a lot of times, but there's two problems with that. One, it puts me in a bad posture. Right? Because now I'm not playing the same type of time game that I can play to put pressure on the plaintiffs, because now we're kind of behind the eight ball, because now the judge has got their eye on our case and they're going, nothing's happened here. Let's get things moving along. Two, and I'll be frank with you about it, it's going to cost you more. If I have to come in, you come to me within that 20-day period, and you say, hey, we got to deal with this. We need to work on a loan modification, a short sale. We want to just defend the suit, whatever the situation is, right?
Initially, at the very beginning, you're talking about. Right at the very beginning,
you come in, I'm going to charge you, one fee. Now, let's say I've got to go get a default lifted. Well, that now means that I have to go in immediately and put everybody else on the side. And I've got to go draft a pretty long motion that goes through all the standards, I'm not going to bore you with them, of what a Florida court looks to lift a default, to prove the case, have you come back in and sign an affidavit. Sometimes it means I have to verify the motion, which means I have to sign it and get it notarized if there's something that happened on my end. It takes me a lot more time and it costs you a lot more money. And while I like making money, I like seeing my clients get the best result possible. And so if I'm looking to keep this case going long enough for your short sale to go through, or giving us enough time to work on the loan modification, time is your friend. But once that default's entered against you, time becomes the enemy. So really, if you got it, I know you don't want to deal with it, you don't want to think about it, you're scared, you're nervous, it's keeping you up at night, come in and do something about it. I have people that come into my office, and I know I've done a good job when they leave a little relieved. Look, the problem's not solved that day. It might not be an easy solution. It might not be.
But at least you have representation.
You have representation, and you know what
and
we're
you don't
doing.
have to deal with it by yourself, and that's a big thing.
Right, and you got a game plan. You know what you're doing. Somebody told me one time, a friend of mine said this in high school, and I thought he was just, cheesy, but it's really, really important. If you fail to plan to fail. Now the second thing that happens, right? People all of a sudden get cheap.
Well, that's what I was going to say, because if you don't have money to pay your mortgage, most of the time you don't have money to pay an attorney, but you work at a payment plan.
Well, we work on payment plans, and really, if you're not paying the mortgage, unless you're unemployed, and you don't have any source of income, okay, I understand that. You definitely, it's time to call legal aid. It's time to call on the resources that you have. Call a relative who can pay for you to have representation. We offer very affordable rates because, we're good at what we do. We do a lot of it. We make it up on volume, and we try to have a little bit of a heart as well sometimes. If somebody really comes in and says, like, this is the situation, and they make me want to cry, I give them the single mother rate. And it doesn't happen,
I should have gone in there crying.
You should have gone in there crying. You would have come to see me. I would have taken care of you just because you're from Brooklyn.
This is definitely, though, not going to go away. That's the most
It's not going to go away,
thing.
but what happens? Somebody will think they're smart. Oh, I can do this. You didn't go to law school, but yeah, I can do this. Right? It's like performing your own surgery.
That's a good analogy. I like that.
It is a good, it is a good analogy.
Today.
Like when you represent yourself, what happens? Immediately, they file a response with the court, and it usually goes something like this. Yeah, I know I'm behind on my mortgage. I'm trying to work it out with the bank. I'm hoping you will help me. They sign it. They file it at the courthouse. They follow instruction on the summons to tell you how to do this yourself. What they don't realize is that by doing that, they're giving up a lot of rights. Because what happens, right? When I finally answer a lawsuit, when I finally file an answer, right? A lawsuit is a complaint. It says, it's a list of paragraphs and says, we say that the defendant did this. So he took out a mortgage. He didn't pay the mortgage. The default happened at this point. We did everything that we needed to do prior to filing the lawsuit. This second mortgage company might have an interest in the property, but it's inferior to ours, whatever the case is. Well, if you say, yeah, I didn't pay my mortgage, you've just now admitted everything in that complaint. You're really taking away the onus from the bank to have to prove it. Now, what I do when I file a response, when I finally get to my answer, when we're done with all the pre-answer motions, pass my motion to dismiss, try to get the case thrown out on a technicality, before all the other stuff that I do, right? Once I get past that, I have to file an answer at some point. I do, at some point, have to admit or deny those allegations. But that's not where it ends. That's where it starts. I admit, what we have to admit. Yes, this is a house of Broward County. Yes, or Palm Beach County, whatever county it is. Yes, they took out a mortgage. Yes, there's a promissory note. No, we don't think that the bank did everything that they had to do before filing this lawsuit. Well, that's grounds for getting a lawsuit thrown out.
Yes.
That's grounds for winning a trial.
Well, people don't know this. People don't. That's why you're here to educate people.
Yeah. Well, as somebody once said to me, so representing, a pro se client representing themselves, even an attorney representing themselves, right? It's kind of like doing your own dental work. You're not going to do a good job and it's going to hurt. And that's really, really what it comes down to. Because the next thing I do and the next step in this, right, is we file affirmative defenses, right? And anybody out there that has kids, right? So you got brother and a sister. Brother hits sister. Did you hit your sister? Yeah, but she hit me first. Yeah, but she took my cookie. Well, normally we say everything after but is BS. Well, not in the legal profession. In the legal profession, everything after but's the affirmative defense. It's saying, yeah, I didn't pay the mortgage, but the bank can't foreclose because X, Y, and Z. They didn't do what they needed to do before they filed the lawsuit. They raised my payments illegally. Whatever it is that we can throw in, we throw in. But
right.
if you don't do that, right, if you don't come in and raise those affirmative defenses, when we get to trial, those affirmative defenses are waived. So one real great example is something we call the paragraph 22 letter. If you ever read your mortgage, so, you're having trouble sleeping, and you get to paragraph 22 of your mortgage, it says that the bank, before they can foreclose, has to send you a letter informing you that you're in default, telling you how to cure the default, giving you 30 days to cure the default, advising you that they can file a lawsuit and force a sale of your home, a bunch of other requirements. Well, if you don't file an affirmative defense saying that this didn't happen, that the bank didn't do X, Y, and Z correctly, even if they didn't, it doesn't matter. So, one of the first trials that I ever took on, a guy comes into my office, I'll never forget, he came in August. Yeah, what's going on I have 2 properties, trying to figure out what's going on, where we're going to stay, we don't have a lot of money, blah, blah, blah. I lay out a plan with him. I said, all right, this is what it's going to cost for me to come in and defend. We're going to let the other house go. You got no chance on this one. You already have a judgment, or I forget exactly what the situation was. The second house, I think we got something good on here. Here's what's going to cost me to defend it, and I give him a price, and this one I'm going to need up front, and then this much, and this much after that. I don't hear from him again. He shows up Valentine's Day. Right, he calls, emergency, I need an appointment, walks in with a trial order. So now he's got an order that says,
and he wants you to represent him.
He's like,
at
now
this
I want to go
point.
to trial. He comes in, he's all smiles, he's confident in me, I'm happy, I think it's a good case. So, all right, come on in. I take a look at the docket, I see he filed an answer. Strike one.
On his own.
Right, don't ever file an answer on the answer.
Right? So now he comes in, and now there's a trial date set. Now I've got about less than 3 months to prepare for this trial. Never easy. So all of a sudden I go, all right, well, this is now how much money I need. Whoa. But you gave me this price in August.
That's right.
You gave me this price in August. Right. That was August. You didn't pay me in August. You didn't hire me then. Now I've got a trial in 3 months. You have to pay me more. Happens to be a reason I share that story. It's a happy story in the end. But so what happens? So now he hires me. He pays the money. He said, we're going to roll the dice. We're going to go to trial on this. Great. Go to the courthouse. I pull his file. I see his answer. What does the answer say?
Oh, no.
I didn't pay my mortgage. I'm trying to work on something with the bank. Please give me a little more time. 3 years. Now I've got to go in less than a month before trial. By the time we get everything together,
but you're the miracle worker.
Sometimes.
Okay.
Sometimes.
He's a litigator.
Well, now I've got to go in, and we're like a month or so before trial. Is the first time I can get into the courthouse. Is the first time I can get a hearing for this case. And now I have an emergency motion to allow me to amend the answer. Courts hate that. They like to know what's going on. Look, this case has been going on. I understand the judge's position. The case has been going on for 3 years.
So they let you amend what he wrote.
So now I got to go in, and the other attorney, I have to say, like, I see the same attorneys day in, day out. One of my paralegals used to do criminal work. Is like, God, I watch your interplay with these attorneys, and it's like the state attorneys and the public defenders of criminal court. They see each other all the time. They always have the same issues. So you develop a camaraderie, you develop a friendship. You help each other out when it's not going to affect your client negatively. You have to really look out for your client's best interest, and that only. I go in, and the other attorney's like, look, man, he's like, if we weren't set for trial, I'd let you amend your answer. I would, I don't care. I understand your guy wants a fair shot. He's like, I can't. I just can't. So now I go up in front of the judge, and I'm like, look, Your Honor, I'm here to amend my answer. We have a trial set in like a month. She's like, you have a trial set in a month. The answer was filed 3 years ago, and you're asking me to amend it a month before trial. Why should I let you?
What was the response?
So I'm like, look, Your Honor, I just want my guy to have a fair shot. I'm not looking to do anything else. I'm not looking to delay the trial. I'm not looking to do anything other than just give this guy a fair shot. Let me try the case, but let me at least raise some affirmative defenses. Let me put in my yeah buts. She looks at the file. She looks at me. She goes, all right, here's what we're doing. I'm going to let you amend your answer. You cannot request any discovery. And I'll get to that in a second. And you can't use... Oh, no, I had requested discovery already. She's like...
Had you been before her before?
Oh, constantly.
Okay, so
she knew who he was.
She knows who I am.
Did you know what you're talking about?
She doesn't know. She's like, listen, she's like, I see that you have discovery out there. If they don't respond to your discovery, I'm not letting you delay trial to compel it. Great, right? I'm not letting you do anything to move this trial date. Your trial date is like set in stone at this point, but I'm going to let you change your answer. So now I don't have one of my most basic tools to get all the information that the bank has in its file about your loan, your correspondence with them, to compare it to what they're going to bring to trial and to use it to win the case. So right now, look, I'm already representing a defendant who we know didn't pay in a foreclosure suit. So I'm already, I've already got one hand. I've already got one hand tied behind my back.
Exactly.
Well, now I've also got one leg, and I'm in a butt kicking contest. Like, it was, not pretty. But I said, look, it's the only chance we got, right? Happened to be, we lucked out because the bank didn't take the case seriously. They're like, oh, they saw the guy was pro se. They never really updated and took a look at what was going on. They came in thinking they were going to have like a 10-minute trial and they were going to blow me out of the water. Instead, the trial went for 15 minutes, and I blew them out of the water.
Good for you. That's incredible.
Yeah, it was.
So what was the outcome? So
the outcome was I got the case dismissed at trial because the bank's representative didn't know anything about the file.
Dismissed meaning what? Because people don't understand.
Okay, so what does dismissed mean? Dismissed means what it sounds like, thrown out. I went to court.
So was he
able
to keep the house?
He's in the house right now.
Okay, that's the question.
The bank at this point, under what is not quite settled law in Florida yet, according to most of the courts out there now, may still have a right to bring the lawsuit against him. They haven't. It's been 3 years. Is
there a statute of limitations for that?
Well, that's the interesting thing. So we talk about the statute of limitations, and for those of you out there who don't know what a statute of limitations is, Florida courts don't want their system backed up with old cases. They just don't. It's not what they're looking for, right? They say, look, if you have a claim, you have a certain amount of time to bring it. So claim for a mortgage foreclosure action and a claim based on a written instrument, which would be the note, the promissory note you sign when you take the mortgage, statute of limitations is 5 years. You have 5 years. If you don't bring it within 5 years, so sad, too bad. But,
so they can't go after you again after 5 years. That's what I'm saying.
Well, you would think. But there was a decision last summer out of the 5th District Court of Appeals in Florida, which is somewhere up in the Northwest. I forget exactly where the court said, look, we understand that there's a 5-year statute of limitations, but you have to figure out, when does that statute of limitations start to run? Well, of course, people like me.
Oh, the courts do, but also.
Of course. Right? People like me are going, oh, it runs from the day they defaulted, or at least from the day that the bank sent the acceleration letter, right? That letter that we talked about earlier, or at the very least, from the time the bank filed the lawsuit. Because in that lawsuit, there's always a line that says the plaintiff now demands the full amount due and payable. So now, you owed us $325,000 at 6% interest, and you were paying it over a monthly over a period of 30 years. Now we're saying the whole thing's due. You got to pay everything right now. So for me, I'm going, well, 5 years from that point, you can no longer ask for it. You can't decelerate. Not according to the courts.
Is that the same thing with short sales now too, with deficiencies?
Deficiency is a little different. There's a whole different set of statute of limitations that were put into effect on deficiency judgments 2 years ago. But let me finish this first, and we'll get back. So what the court did, they said, look, mortgages are unique. It's like an installment contract, right? Every month you have another payment due. So what this court in the Fifth Circuit said was, well, really, you have a new event of default every month. So until you hit the end of that mortgage term, so if you took out a mortgage in 2005, it's a 30-year mortgage, it's over in 2035. Well, if the bank hasn't filed suit to foreclose by 2040, we know that you're in the clear.
Aye.
That's a long time in the future. Well, here's the thing.
That's not good.
Well, it hasn't gone up in front of the Supreme Court yet. And I think that's a little hesitation on both sides. I think both of our sides want to have the perfect case to bring up to the Supreme Court. One that shows that for banks want to have one that shows that it would be monumentally unfair to enforce a 5-year statute of limitations. And of course, we as the defense bar would love to have the perfect case that we can show the courts that it would be monumentally unfair to take it out any more than 5 years. And so far, that perfect case hasn't come up.
Right, because people think they're safe with their mortgage. They're in their house.
Right.
And then 10 years later, they could have it taken away from them.
Right.
Or be sued again.
Right.
Or even 15 years later have to be represented again for that.
Yeah, I've had a great year of dismissals. A lot of cases that have gone to trial that either I've gotten dismissed or the bank's just dismissed when I walked into trial prepared. And for various reasons. And I will tell you, of those clients, I have yet to have one see a new suit filed against them. There are other people who tell me their clients have had new suits filed against them. So we're first starting to get to these issues. Maybe it's just luck with my clients. Maybe the bank's trying to get its paperwork together. I don't know why. I'm not the decision maker. I'm not the bean counter. All I know is, eventually the bank is going to file a new suit, and they are going to come in. But, if you haven't paid your mortgage for 5 years, and then I get the case dismissed to trial, and now the bank's got to start all over again. And now, we're in for another 2, 3, 4 years before we get to a trial again. Well, that's a long time that you haven't been paying a mortgage. So one of two things is going to happen in that time period. Either things are going to turn around. We're able to work with the bank on a loan modification. We'll be able to do something. Maybe you want to do a short sale. There are the people that are just in such a state that they can't make a decision on what to do now. We just need to kind of hold this thing off until we can figure it out, until we can do
But you bought them a lot of time, though.
Exactly. I bought them a lot of time. You have a lot of time to prepare. You have a lot of time to do things.
Save money.
Hey, we got to go to break.
Yes.
And when we come back, I feel sorry for people who go through this, but at least we're able to give them a show that I know someone's out there right now going, this is me. I got to stop not doing something with this. I've got to get representation. Give everybody your phone number before we go to break.
I should have given that like a half an hour ago. 954-596-0669. That's our phone number. You can call, schedule a free consultation. We'll be happy to take you in and see
Website?
you. Check us out on the web, www.bilulaw.com. You can like us on Facebook, the Law Offices of Bilu and Bilu. Or, of course, if you don't want to do any of that, you have no attention span, at GBilu. You can follow me on Twitter. I try to put up some interesting information.
Beautiful.
Perfect.
We'll be right back with Gil Bilu.
At the law firm of Bilu and Bilu, we can help you if you are facing foreclosure. Don't lose your home due to foreclosures by the bank or mortgage company. Call the law offices of Bilu and Bilu at 954-596-0669. You have rights and we can help you exercise them. At Bilu and Bilu, your first consultation is always free. If your home is underwater or you are behind on your mortgage and you're confused about what to do, we can help. Call our office today, 954-596-0669 or 1-877-BILU-LAW. That's 1-877-BILU-LAW. At Bilu and Bilu, our lawyers have more than 20 years combined experience in real estate law. The banks have lawyers, and so should you. The lawyers at Bilu and Bilu can help you modify your loan or apply for a short sale while they defend your case in court. Contact the lawyers at Bilu and Bilu today so you can sleep easy tonight. Your home is your castle. Trust the professionals at Bilu and Bilu to defend it for you. The law office of Bilu and Bilu handles foreclosure defense in Broward and Palm Beach and all 67 Florida counties. Call the law offices of Bilu and Bilu today at 954-596-0669 or visit us on the web at bilulaw.com. That's BILULAW.com.
You know, sometimes you're lucky to have one of the top foreclosure defense attorneys in all of Florida. I think I said South Florida before, but all of Florida.
All of Florida.
Yes.
But you're even luckier when you have the top foreclosure defense attorney whose birthday is today. Happy birthday,
Happy
Gil.
birthday, Gil.
Thank you very much.
And
I
like you
appreciate
said,
it.
he told you it was his birthday.
Oh, you had to
Thanks.
tell everybody that.
I have to tell everybody. See, if you would have
Wonderful.
emailed me, I would have wished you happy birthday from
There
the
we go.
get-go.
Very
But
good.
many more, Gil.
Yeah. And hey, I appreciate the birthday present. I got an hour show today instead of half an
Yeah.
hour.
Yes.
So there we go. I'm digging it. I'm loving it.
You know what else? I'll tell you something else is that Gil has been with us from day one. So we kind of have a soft heart for him. But
There we go.
I mean, when you've got the best, and we're always, we do a lot of work making sure we get the best. And it's funny when you tell the
We do our
attorneys,
due diligence,
when they
yes.
see your law firm, they go, "Oh yeah, I know them."
Everybody knows you.
So let's get back to what we were talking about. Listen, one of the things you don't want to do, and I'll bet you they don't care about holidays, do they, when they serve you?
You know what? The only county so far down here that cares is Broward County. Broward County under Judge Marina Garcia Wood, which I think she was the queen of foreclosure 5 years ago. She ran that division. She said, I'm establishing a moratorium, and we are not doing foreclosure sales from, I think it was like December 15th to like January 3rd.
Wow.
Just on sales. You still had trials. You still had everything else. That has held on in Broward County. Well, I mean, it's okay news. It's like, well, you're not going to be thrown out of your home on Christmas. A couple days later, you know.
Right. What's the difference?
So I mean, it's nice, and it's nice to know that we have a judiciary down here that really does care about the people. Look, very, very seldom do you see a judge that's happy, to be throwing somebody out of their house, with rare exceptions. For the most part, we have phenomenal judges. We've been, there's been a deluge. Just the amount of cases that have gone in to the foreclosure divisions in the last couple of years have been overwhelming. So one of the things they did, they brought in retired judges, senior judges. Right?
Is that why the cases are moving quicker now?
That's why they're moving quicker. They bring in the senior judges. They pay them a per diem to be there on top of their pension. And, for the most part, they're phenomenal judges. A lot of them are fantastic. But, the side effect is that things move faster. And it's just it's just the symptom of the problem is that there's so many that it was clogging this court system. They had to bring people in to start moving it along faster. Well, now that it's being moved along faster, we're working with the judges. And I will tell you, especially in Broward County, we're really blessed. Because a lot of the judges, we've got a lot of volunteer senior judges in Florida, not really volunteer, they get paid, but they have to, agree to do it. We're very lucky to have no less than 3 former judges from the 4th District Court of Appeals. So these judges are not only, they're not only former circuit judges, which is nothing to sneeze at in and of itself. You work at the trial level, you work in circuit court, you got to be pretty good, you got to have your chops. Now, when you've gone up a level to the DCA, to the District Court of Appeals, Well, now you're really become an expert, and you're really dealing with very technical issues of law. You're dealing with a lot of evidence, right? You're dealing with a lot of evidence-based objections. And I don't know any specific study on this, but from doing the work we do on appeals and the research that we do for a lot of our cases, one of the main issues that comes up in any appeal is evidentiary standards. And, this is something that these judges are really boned up on. It's something that they really know because, you know what? They wrote a lot of these groundbreaking opinions. When the Florida Evidence Code was first devised, I think it was in the 60s. It's very similar to a lot of evidence codes elsewhere in the country. You were dealing with things as they were in the 60s. You had carbon copies and mimeographs, but you didn't have scanners, you didn't have emails, you didn't have faxes, you didn't have all these things that we have today. And these are real issues that have to come up, that have to be dealt with. And that these judges went and applied these old rules to newer technologies, and so they really know it, and they know it really well. And we're really lucky to have them in a lot of cases because, look, there's only one great defense to foreclosure. Look, I paid, and here's the proof.
That's it, but a lot of people didn't.
Yeah, it's like 1 in 10,000.
No, I'm saying, right.
So now I got to come up with technicalities. I got to come up, well, the bank didn't do this right. This wasn't credited right. Their witness isn't qualified to speak. This isn't a valid copy of the mortgage that the court can consider as evidence. All sorts of things. Very, very technical stuff. Makes me happy that I did as well as I did when I took evidence in law school. But to have these judges that are, one, the ones that wrote some of these groundbreaking opinions on it, and two, look, they worked with a lot of the judges that are on the court now. The last thing that they want to happen is to make an incorrect ruling on a law that they kind of helped write and now have their former colleagues go, Judge so-and-so, you wrote this ruling, but you got it wrong. Like how, like a trial, a senior judge who was only a circuit level judge. Oh, I shouldn't say only. It's a major accomplishment. A senior judge that only went up to be a circuit judge. Didn't go past there either by choice or for whatever reason. Didn't go up to a district court of appeal. He gets overturned by a judge. Doesn't matter. He doesn't have a judicial career anymore. He goes, okay, I messed up, and nobody likes messing up, but it's not the end of the world. But when you wrote a groundbreaking decision on some area of evidentiary law, and then you make the wrong ruling at trial, you're embarrassed, and you should be. And what I will tell you is these judges that come in from the 4th DCA that do our trials, they do a lot of our trials. Absolutely phenomenal. I had one trial this past summer that I won. It was fantastic. I was happy to win in any event. I got to sit down with the judge afterwards. And I will say all credit to my opposing counsel. She was phenomenal. She did a great job. I didn't know how the judge was going to rule. I was hoping I was going to win, but I wasn't as sure as I have been in other cases. Well, afterwards, we got about 15 minutes to sit down with a retired fourth District Court of Appeals judge. And she critiqued our trials. And that, for me, was better than winning, because what a great thing to learn. To say, hey, this is what you did great, and
this is how you won.
This is what you could do. Well,
right.
This is what you should have done better.
Oh, really? Interesting.
Yeah, that was the most important part. Was this is what you could do in the future. This one issue helped you, but you had these other issues that you could have done X, Y, and Z on.
What percent of your cases go to court?
That's a really, really tough question to answer. I mean, look, they're all in court.
Because I have a follow-up. Let me tell you something.
Yeah.
I remember one of the times when Gil and I talked, I want him to represent me. I'll tell you why. He is a bulldog. He said, let's talk about litigation. I love litigation. Now, there's attorneys out there who are afraid to litigate. This guy's a bulldog.
I know.
This
and a lot of people that are listening that have been served or stopped paying their mortgage need to understand what you mean by winning. Are they winning to stay in their home? Because, we're talking we have to talk a little bit more in layman terms so people understand that once you serve papers for foreclosure, you could actually have them stay in their house. I mean, that's a possibility as well.
Right. Well, and here's the thing, also when we win, we get the case thrown out. And like I said before, the bank can still refile suit, can still try to come back. But we've now ratcheted up the pressure on the bank because now they've lost. So they've already got, a couple years down the tubes where they've been paying the taxes. A lot of cases they've been paying the insurance. Obviously, they haven't been collecting interest, right? So we've already ratcheted up the economic pressure on them. It becomes a lot easier the second time around, or it should become a lot easier the second time around, to settle the case with the bank. if that is what you're looking for, to get that loan modification, to get that short sale.
And you can still do a loan modification. If you serve foreclosure papers, you can still do a loan modification. Is that correct?
Absolutely. You can do a loan modification anytime up until the sale of your property.
Okay, let me ask you another question. If you're upside down in your mortgage, because a lot of people are upside down because of what happened with the housing market years ago, and then the housing market took a dump. So I know people that have tried to file for a loan modification. And obviously, they need to come to you.
Right.
That's aside from the fact, but I'm just saying that you could still do that if the house is appraised for less.
Right, absolutely. And what we were seeing a lot at the beginning of the crisis back in 08, 09, we were seeing a lot of principal reductions. We would see the bank say, look, the house is worth, $200,000, you owe $400, your income's dropped significantly. In order to make these new loan payments work and fit in your budget, not only are we going to reduce your interest rate, we're also going to take $150,000 or whatever of your principal.
They do that.
And we're going to defer it at first, and then eventually, in some cases, not in every case, we're going to forgive it. Doesn't happen in every case. It varies from loan to loan. It varies from case to case. It varies from borrower to borrower.
So what are the qualifications? How do you qualify for something like that?
Well, one of the big qualifications is just to be in the right place at the right time.
Like your office.
Well, my office is one way to do it. And again, before we forget, you can call the office for a free consultation, 954-596-0669. Check us out on the web, www.bilulaw.com, or follow me on Twitter at gbilu. And I'll tell you, even if you can't come in our office for an appointment, I have a lot of clients that live in other states, in Nevada, New York, Michigan, Illinois, Wisconsin, California, just to name a couple
How
off the
about
top
Martin
of my head.
County? We have a lot of listeners.
Yes, but you represent them as well
I
in other
definitely work with
states?
people in Martin County. I represent people that have Florida properties that live in other states.
Oh,
Everybody was
gotcha,
coming
okay.
down here and buying properties because the prices were appreciating so fast.
Yes.
We do phone consultations, no problem. We do a lot of work over email. We can give you a credit card form that you can fill out and email back to us. We can take it over the phone. If you've got the desire to have representation down here, we'll find a way to make it happen for you. You don't have to come into our office. There are people, look, I have clients that have two jobs, 3 jobs. They can't get into my office for an appointment. I understand that. We do a lot of work with them over the phone. Sometimes we'll do an evening appointment if that's, if we need to get somebody in. We have certain nights every month that we try to set aside a little time to have appointments till 7 o'clock, just so we can help these people out.
What percent of your business is foreclosure defense?
Right now, it's hard to say. Why do I say it's hard to say? Because a lot of times it's blended with a lot of the other things that I do. So yeah, we do the foreclosure defense. But we could be negotiating a short sale. We could be working on a loan modification. We could at some point be filing a bankruptcy.
But you're not doing criminal law, or
no.
You're not doing
This is
employment
his
law.
specialty.
This is what you do.
We do other civil litigation as well. We do business collections. We do work with our clients, in some of their corporate needs. We do help out our clients in other ways as well. But I'd say, our bread and butter, probably foreclosure defense and foreclosure defense related activities, a good 75% of what we do.
Okay, so I have a question for you. So if you go to if you end up foreclosing your home, people think that the bank just takes over the property. That's it. Can they come after you for money?
For sure.
Okay, because people don't understand that.
Right.
And the same thing with a short sale for deficiencies. So let's talk about that.
Well, those are two different sides of the same coin. So
Right.
let's say the bank gets a judgment against you for $250,000. Your house is worth $100,000, right? Well, the bank's now the house has gone to sale on the courthouse steps, and let's just make it easy. The bank takes it over because nobody else wanted it. Well, now the bank has a year. It used to be a lot longer. The Florida legislator did shorten this. Right now, if the bank got a judgment, earlier this year, and the sale is 2 months from now, they have a year from that sale to come in and ask the court for a deficiency judgment. They come to the court. They say, "Look, we had a judgment for $250.
This is for foreclosure,
right? We got a house worth $100, and we would like a judgment for $150,000." Now, if you didn't defend your case, you don't even get notice of that hearing half the time. And they don't have to give you notice because you've been defaulted. Some judges are now requiring it, but that's certainly not required under Florida state law. If you defended the case, at least we have the opportunity to come in. But the opportunity we have to come in is just to say, well, maybe the house was worth a little bit more.
So can you get rid of those deficiencies for a foreclosure?
There are a couple ways to get rid of the deficiency. And again, this goes back to the ostrich comment at the beginning of the show, right? The best way to deal with that deficiency is to deal with it up front. And I'll give you a great example. I had somebody come in that actually had a judgment against them. And this was just a miracle, literally. I managed to get the judgment vacated because of improper service. Really all went down on my client's credibility. I brought them in to testify. The judge believed that they were never properly served with the case. This is an issue that, unfortunately, the banks have gotten much better about, and the process servers have gotten much better about not cutting corners. Managed to get it thrown out. We were working on a short sale. We had one or two fall through already, where the buyer just couldn't come up with cash to close. Now I've got a trial date set for, I think, December 17th. I'm going into court tomorrow afternoon, actually, to ask the court to postpone the trial again because we're working on the short sale. But what happens if I can't get the short sale done? All right, let's say our buyer backs out again, or the bank rejects the short sale. The bank's under no obligation to look at that short sale and say, okay, we're going to take less money than we're owed and settle the debt. The bank can always say, no, we want more money. We want a higher purchase price. And I've had banks come back for properties that aren't worth more than $90,000 and say, well, we'll do it if we can get a purchase price of $130,000.
Wow.
That's not going to happen. So what's the next thing I do? I go into court. Now we're staring down the barrel of a trial. My client's got a decision to make, right? Are we going to try this case? Or are we going to roll the dice? Or do you have too much to lose by rolling the dice here? And depending on the strength of the case, the strength of what I think, my opposing counsel is going to be like, their evidence that they're bringing in, sometimes it's going to be a better move for my client to settle. And I'm happy to do it when it's the best thing. So this case in particular, if I'm going to move the trial, well, what happens if the trial doesn't get moved? Well, the next thing I'm going to do is try to work with the bank's attorney to settle it prior to trial. Enter into a consent judgment. Say, hey, look, we're going to agree.
Which means what?
We're going to agree to a judgment that says all your figures are right. We owe you, X amount of money. But as a trade-off for not making the bank take their case to trial, because when I say roll the dice, that works both ways. My mentor told me this. It was when I started doing a lot of litigation. He said, there are cases that you are going to win that you should have lost, and there are cases you're going to lose that you should have won. And any attorney who tells you different hasn't tried enough cases. And I really, really took that to heart. And look, this is a big deal with my clients. Whether or not it's a house they live in, it could be an investment property. It's still a big deal. Nobody wants to walk away from a trial not only having lost, but now having a $200,000 deficiency that you owe the bank. So what we try to do in a situation where we think it's going to be in our client's best interest to settle because it's not a good case or the financial risks are too great for them, whatever the situation is, we try to work with the bank on what's called a consent judgment. We agree to the bank's figures. In exchange, the bank will agree to give us an extended sale date, usually 90 or 120 days. In some extreme circumstances, I've gotten it up to 150 or 180.
To short sale the home?
Well, to try to work on a short sale. But here's the thing. What do? We come up with Plan B, right? And Plan B in that case is a waiver of deficiency. We get the bank as part of that judgment to agree to waive any deficiency. So look, you get the judgment for $300,000 and the house is worth $100,000, but you waive the right as the bank to come after that additional money. And sometimes that is going to be the best thing for a client. And as much as I love trying cases, I love to be a bulldog, as Steve likes to call me. Ultimately, what I have to do is look out for my client's best interest.
Absolutely. And people, that's what I was saying to you, that a lot of people think that once they foreclose, that's it for them.
Yeah.
That there's no monies owed, but that's not the case. And the same thing with the short sale, which I learned the hard way.
Right. And we've talked about this
Yes.
before, and when you have, and no insult to my realtors out there. I love my realtors that have stuck around.
But they're not attorneys.
They're fantastic. They're not attorneys. Their main goal, of course, is to make their client happy. But look, they want to get their commission. They want to get it to close.
Yeah.
And also look, they didn't go to law school, so they don't understand everything. When your short sale is approved, it's not just like the bank says, "Oh, okay, great, do the short sale." You get a short sale approval letter, and it lists out specifically what's going to happen, when it has to close by, who your buyer is, what the purchase price is, and the minimum net proceeds that the bank wants to see from the sale. It also lays out the terms of your settlement. And one of the most important terms of the settlement is what we were talking about before: deficiencies. There are some short sales where the bank says, because this is an investment property, because your client has assets, whatever the situation is, we are not willing to waive the deficiency. Now I've got to have a tough conversation with my client. And I say, look, I've already gone back to the bank because I never take no for an answer right up front. Bank says no. I said, why not? What can we do to make it happen? Can we can we agree to sign a promissory note for, $10,000, pay it off over 10 years, whatever the situation is? Can we come in with a little cash at closing and, give you that in lieu of the deficiency? We try whatever we can to take care of that deficiency at the closing table, even if it means our client settling for 5% of the debt, 10% of the debt. It's still less, right? But a realtor's not going to know to do that. They're not going to have that in their arsenal for the most part. And they're maybe not going to be effective at explaining to a client. And not because they're not intelligent, not because they haven't been in the industry for a long time, but that's not what they do.
It's not what they do.
Right.
They never even, I told you last time, and I tell you month after month, they never even let me know that was even going to be the case.
Right.
Which is a scary fact.
That's a really scary fact, and really, really shame on them. Because I've seen realtors that do that, and I've seen realtors that don't. I've seen realtors that say, look, I can't get your deficiency waived. This is the best I can do. And I'll tell you, sometimes it's still in your best interest to go ahead and agree and let that deficiency be there and negotiate it later if the bank won't finish it now. I don't normally want to do that. I've had a few cases where it's actually been the best route for my clients. Say, look, it's going to leave you with a $100,000 deficiency, but we're wiping out $500,000 of your debt. There's $100,000 left that we're going to have to work on in the future, but you've already taken out a big chunk of it by doing this short sale, by doing this closing.
Or they could incorporate, if they have to do a bankruptcy, they could do that as well, because the foreclosure or the deficiencies for foreclosure or short sale can be, and you do bankruptcy.
And we do bankruptcies as well. And actually, something really interesting I want to talk to you about bankruptcies. Before I do that, I got to give myself one more shameless plug. Give us a call for a free consultation, 954-596-0669 or 1-877 Law.
And tell everybody where your office is located as well.
We're in Pompano Beach, conveniently located between the Turnpike and I-95. Very easy to get to from anywhere.
So easy to get there.
Yeah, Steve likes to drop by just to see if I'm in
sometimes.
sometimes.
They have gas right down the street for $2.82, so it's worth going there.
Yeah, but the lines there are on lunchtime. You think they're giving things away. To save the gas that I sit burning while I'm waiting online, I go across the street. I pay 4 cents more a gallon.
Okay,
especially because I drive a Prius. But yeah, there's actually a very interesting development. There was a case about 2 years ago. We'll back up for a second. So when you file for bankruptcy, what happens? You have two types of debt, secured and unsecured. Well, secured debt is obvious, mortgage, car loan, that sort of thing. Well, what happens when you have a secured debt that doesn't have any equity stakehold in your property? What does that mean? You have two mortgages on your house. First mortgage is for $300,000, second mortgage for $100,000. Your house is only worth $200,000. Well, your first mortgage has an equity stakehold in the house, right? They come first. They've got an equity stakeholder. They say, look, there's equity from our perspective in the house because if this goes to foreclosure sale, we get paid. Second mortgage is not in that same position.
Right.
Well, it used to be by going and filing a Chapter 13 bankruptcy, we could do a motion of value collateral, and where we go to the court and we say, look, we know this is an equity line secured to the property. We know that ordinarily it's considered secured debt. However, the house is worth less than even the first mortgage. So really, they should be treated like an unsecured creditor on this property. And we believe that, and under federal bankruptcy law, that lien should be stripped from the property. They should be treated like an unsecured creditor, like a credit card or a doctor's bill. And that lien should be extinguished. And you would go through, we have to hire an appraiser, there's an evidentiary hearing.
And a lot of people have second mortgages now, so that really,
a lot of it is just sticking on the house, right? So used to be you could only do that in a Chapter 13. Well, the downside of Chapter 13 is it takes somewhere between 3 and 5 years, and it involves a monthly payment to the U.S. Trustee's office, who is then using that money to settle out your debts. Well, I like Chapter 7 bankruptcies, liquidation bankruptcies. They take about 100 days if they're done correctly and there's no issues, and they generally will end up pretty quickly. The only problem with the Chapter 7 is that the way the bankruptcy courts interpreted the law, you couldn't use a Chapter 7 to strip a second mortgage off your property. Well, last year, the 11th Circuit, of which we're a part, said, wait a second, I'm not reading the law like that. And there was a decision passed, I think it was Weaver or Miller, I cannot remember for the life of me. I was just reading the decision today. And the court basically came down and said, no, we're going to strip off this second lien in a Chapter 7 bankruptcy, which is a huge, huge victory for the debtor. There are a lot of attorneys down here that are much less conservative, lowercase c, with their strategy when it comes to things like this. And they said, look, we're going to make test cases for a lot of our clients. They got nothing else to lose. We're not going to be able to do a Chapter 13 for whatever reason. Let's roll the dice, do this as a Chapter 7, make that motion to strip the collateral, to revalue the collateral. Worst comes to worst, we convert this over to a Chapter 13. And they started.
Does that affect your credit less than a Chapter 13?
Both of them are still, your debts are still going to be reflected as settled in bankruptcy. So the effect on your credit report is going to be the same. However, the effect on your life is going to be vastly different. 90 days versus 5 years.
Right.
That's a huge difference.
It is.
And so now the Supreme Court just last week agreed to hear an appeal based on that issue. So the U.S. Supreme Court is going to be handing down a decision, hopefully in the next term, that's going to answer this question for us. And if they come down on the side of the Chapter 7 debtors, if they come down and say, no, you can strip a lien from a property in a Chapter 7, it is going to be a game changer down here. We are going to see a completely different world of Chapter 7. Because now you might be able to go in and say, okay, I'm current on my first mortgage. I'm behind on my second mortgage. There's no equity in my property. I'm upside down. I've got other debt that I can't deal with. I meet the other qualifications for bankruptcy as well. And I want to get this stripped. And that can make the difference for a debtor.
That's huge.
It's a huge difference because, look, in order to do a Chapter 7, you have to qualify in any event. Chapter 7 is not a get-out-of-jail-free card.
Right.
Chapter 7 is not a game. Since 2005, the federal government and bankruptcy courts have taken a much more serious look at bankruptcy and really said, look, we are going to give somebody a Chapter 7 bankruptcy, which most of them end being no-asset cases, which means that your creditors get nothing, right? And as much as we want to be fair to debtors, we want to be fair to creditors as well. And if a debtor has the ability to repay at least a portion of their debts, even though they would otherwise qualify for Chapter 7, we're going to make them do a Chapter 13 so that some of these people that lent the money get their money back. And look, I can be objective and understand that as an academic. It comes to my clients. I fight for what's best for my clients. So this is by no means like a free pass. But if this goes through, and it's something we're all really, really keeping our eye on, if this goes through, it might be something that pushes people over the edge in a good way to say, you know what, I'm going to file that Chapter 7 because now, on top of getting rid of that $20,000, $50,000, $100,000 of credit card and medical debt that's choking me, that I'm fighting to pay every month along with my second mortgage, I'm going to get myself the fresh start that I need so that I can build the future that I need for my family.
And I think a lot of people, especially here in South Florida, have gotten themselves in trouble again because of the housing market, because of the second mortgages, because they're upside down in their mortgages. And I think that's a good thing.
Right. And look, part of this was also I think a victim of the easy money of the early 2000s. I had one client, unbelievable. I mean, his house, he had a first mortgage for $417,000. Second mortgage, took a little equity line, I think, to put in a swimming pool, is like $40,000 or $50,000. And then they gave him a third mortgage for another $450,000. That was great when his house was worth $1 million. Not so great when his house was worth $500,000.
That's exactly it.
And he stopped paying all the mortgages. In the end, he's actually he's doing a Chapter 13 bankruptcy with another attorney, and no fault between us. I was a lot more comfortable with him going with this other attorney for various reasons. This guy's been a long-term client. I handled a lot of cases for him. I was a lot more comfortable ethically with him taking his bankruptcy to somebody else that was really going to push some of these issues that I felt really needed to be pushed by another attorney. It's long, it's complicated. I can't get into it for attorney-client confidentiality. But look,
You'll tell us in private.
No, I won't.
When do you think this ruling's going to come down?
Sometime in the next session. We don't know. Hopefully the session, I think there's a spring session this year. I always forget the Supreme Court sessions. I should be embarrassed to say that, but I'm not. I can't follow everybody. I can't keep everybody's calendar. I can't keep my own calendar.
And, by the way, we didn't even mention this. Another neat thing about going to Gil's website is you can watch all of his past shows. And we've got some incredible shows that you can really get a lot of great information. So give them your website.
Right. www.bilulaw.com. Hopefully you're on there now watching the live stream. If not, it'll be archived on there. There's a big old picture box with my face on it. You just click on it and you'll link through to the Ustream.
Yeah.
Is that where it's on? It's on ustream.com. You can follow through our shows. We've got our whole channel now. It's a whole lot of fun. I used to joke around that I have a face belt for radio when I was doing other radio shows, but here I am. I'm still beautiful.
Now you have a face for TV.
I have a face for TV, right?
There's
Just not
so
HD.
much great
Right, me either.
information on Gil's website. And then you also work with your cousin.
Yes, I do.
We got to say hi to the cousin. Are your kids watching today?
Probably not.
Dad's on.
As cool as I am, they're a lot more interested in the Avengers.
That's usually the case.
Yeah.
And what's the Bilu's doing for Thanksgiving?
Actually, this year we're driving up to Orlando, but I'm bringing my turkey rig up with me, and I'm frying the bird up there.
He's trying
Should
to
be a lot of fun.
He does the fried turkey. I know. He told me that last time.
You got to take a
which
minute
is
out. You got to
interesting.
fry the bird. It is not only is it the tastiest way to eat a turkey, it is a lower fat way to eat your turkey than an oven roasted
I know,
turkey.
surprisingly enough.
Surprisingly enough, and oh my god, it's amazing.
Okay, give your phone number out.
954-596-0669, 1-877 Law. Check us out on the web, www.bilulaw.com, or at gbilu on Twitter. Not only do I put up foreclosure-related content, I put up a lot of other fun content. It's a great way to engage, communicate with our clients. Just the other day, I ran into one of my clients in a store about an hour and a half after a consultation. It was actually just hysterical. And she comes up to me, just gives me this giant hug. It really kind of felt cool lately. It was just, I knew that I made a difference in this woman's life.
Can we tell you? I mean, you are blessed, man.
Yeah.
You keep people
In their
roofs over
homes,
their head,
yes.
and
Which
'cause
is
we all
huge.
listen. We all screw up, okay?
Yeah.
And to be punished and put out in the streets. So anyway, we thank you for what you do. We
Thanks
thank
and
you for being
happy birthday, Gil.
Thank you very
Bilu
much.
and Bilu.
Thanks for
Law.
coming in today.
We'll see you again in December. Thanks so much for listening today. Without you, there is no us. Peace and love.
We're out.
Thanks for tuning in today to the Ask the Experts show with Steve-O and Renee. Tune in every Friday from 4 to 5 p.m. while some of the top local experts in their field from Broward and Palm Beach counties educate you in the areas of law, health, financial, and home improvement. You can also call our offices at 888-574-6999 to become an expert on our show. The opinions expressed on the preceding sponsored